It's very good to be a Marion for Move to Amend. Thank you for having me. Well, let's get to it. What was a corporation exactly back in the early days of our founders? In the minds of James Madison, John Marshall, and other founders, it was an artificial creature of the law with no other rights than its charter said it had or that it required to complete its purpose. To build a road, build a bridge, put up a building, whatever. It had special privileges, such as limited liability, but it had no constitutional rights whatsoever. And most state charters only lasted 10 or 20 years, and they had to be renewed. They could be revoked, and they sometimes were revoked, if the corporation was found to not be acting in public interest. What about those inalienable rights listed in the Bill of Rights? Well, those were the rights of natural-born persons, period. Free speech, religion, assembly, and all the others were personal rights. They were not corporate rights. And if corporations were going to have special privileges that helped make them rich and powerful, which they did, then government would have to regulate them with scrupulous care. Thus, like moth to a flame, the Supreme Court of the United States was drawn into the task of regulation. Regulation. And the court began to build a huge body of constitutional case law on corporations that was suddenly overturned with the 1886 Santa Clara decision. That's Judge Waite, all right. There he is right there. Let's have an early example of one of these constitutional cases. In 1839, the Bank of Augusta versus Earl. What did the Supreme Court rule? It ruled that corporations might be treated as citizens in federal court so as to hold them accountable for wrongs. But those corporations could not claim the constitutional rights of living persons. They could not. And so it went, case after case, decade after decade, as it should have continued. But corruption intervened and changed the game plan in 1886.
I must object. My name is Morrison Remick Waite, Chief Justice of the Supreme Court from 1874 to 1888. I was educated at Yale, Phi Beta Kappa, skull and bones, and practiced law in Ohio, much in the defense of railroads and big corporations. And why not? Railroads in those days were the shapers of cities, bringers of dreams, modernizers and wealth builders. It's true that I had no judicial experience before President Grant appointed me Chief Justice. And I was not his first choice. In fact, I was his seventh choice. Many were dubious at first, but I proved them wrong. Soon I became known as a quick study, honest and industrious to a fault. I served until my sudden, unexpected death in 1888. And I can tell you that my ruling in Santa Clara was completely correct and legally unassailable.
Thank you for your service, Judge Waite. But I have to disagree with you, and let me explain why. So we had all that standing case law saying corporations did not deserve the constitutional rights of human persons from the birth of the Republic right up through 1860 and beyond. But then something very odd happened in the 1880s. Very odd. And it happened because of two results of the Civil War. What were they? First, the Civil War made railroads richer than God. Now they could get the very best lawyers, rented by the ton, to help them fight the enemy of expediency, government regulation.
Perfectly legal.
Yes, I agree. Second, the Civil War inspired Congress to write the 14th Amendment in defense of the human rights of newly freed slaves.
Good idea, but hard as hell to get approved.
But it was ratified in 1868. The 14th Amendment was supposed to protect freed slaves from abuse by Southern legislatures. This is what it says in Section 1, which speaks famously about due process and equal protection. Quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, can anyone doubt that the words of the 14th Amendment were meant to protect the recently freed slaves from Southern legislatures? Hard to imagine how anybody among today's defenders of original intent, like Scalia, claim 14th Amendment protections for corporations. Quite apart from the plight of freed slaves, those clever corporate railroad lawyers saw the 14th Amendment as simply a handy weapon, a very handy weapon, in the fight against regulation. Against regulation. If they could just persuade the courts to declare that corporations were persons. Corporations were persons. Then corporations could evade state regulation under 14th Amendment protections, the same protections that any natural person, except a woman, of course, even a freed slave, could claim against state laws. Now, this new kind of legal assault began right away in 1869, right away. But the Supreme Court continued to reject the corporate claim to 14th Amendment protections. It did so as late as 1880, when it upheld a state's right to ban lotteries in a case called Stone versus Mississippi. Isn't that right, Judge Waite? You became Chief Justice in 1874, so how did you vote in Stone v. Mississippi?
Yes, but that was an entirely different...
Don't bother, I looked it up. I thought it was advisable to look it up myself. You not only concurred, you wrote the majority opinion. And your opinion even quoted Chief Justice Marshall to this effect. These are Marshall's words that you're quoting. Quote, the framers of the Constitution did not intend to restrain states, in the regulation of their civil institutions adopted for internal government. And the instrument they have given us is not to be so construed. You may sit down, Mr. Waite.
Now see here, Professor.
Mr. Waite, this is not your court. This is the court of public opinion in Marion, Iowa. You must wait until we ask you to speak. Thank you. Now comes the great puzzle. Why did the Supreme Court of the United States suddenly about face on the momentous question of corporate personhood? Were you culpable, Judge Waite, as Chief Justice? Maybe later. 125 years ago, in 1886, in a simple property tax case, the railroad hired guns got their opportunity to avoid state regulation in the Santa Clara County versus the Southern Pacific Railroad Company case. This simple tax case about fences the railroad built along its rails had nothing at all to do with corporate personhood. And yet, almost any professor of constitutional law, I don't care what school he's at, Harvard, wherever, will tell you that this case was the precedent for corporate personhood. Ladies and gentlemen, it was that precedent in 1886 that gave corporations all the constitutional protections Congress meant for freed slaves when it wrote the 14th Amendment. All the constitutional rights that were intended by our founders for us, for we the people. Those of us who are human persons, that is. Now, it was this 1886 precedent that created the legal foundation for rights that today, enable the owners of corporations to break free of regulation, to avoid the monitoring of environmental protection agencies, and to acquire the vast economic power that now dominates our government and permeates our culture. In 1886, 125 years ago, corporations usurped the rights of individual human persons and have consistently used them against us. Indeed, it was that precedent that gave us Citizens United in the year 2010. And you, Chief Justice Waite, you were part of that theft. Wasn't it your decision in Santa Clara v. Southern Pacific that established the precedent for corporate personhood?
Absolutely not. I did nothing wrong. That was not our decision. Go back to school, Professor. Learn a little more about court history before you slander me.
Well, just a moment, Your Honor. Wait a second. Oh, there it is, right there. What about that famous quote of yours? It's here, in a note to you from John Chandler Bancroft Davis, your court reporter in that case. It's probably no accident, by the way, that Davis was a former railroad president. Let me refresh your memory, Chief Justice. It's dated May 25th, 1886.
Dear Chief Justice, I have a memorandum in the California cases Santa Clara County versus Southern Pacific Railroad Company as follows. In the opening, the court stated that it did not wish to hear argument on the question whether the 14th Amendment applies to such corporations as are parties in these suits. All the judges were of the opinion that it does. Please let me know whether I correctly caught your words and oblige yours truly, J.C.B. Davis.
Yes, but that was just my passing comment, not part of the opinion. You need to hear my complete reply to Court Reporter Davis. I happen to have a copy right here. I told Davis, I think your memorandum in the California Railroad tax cases expresses with sufficient accuracy what was said before the argument began. And I leave it to you to determine whether anything need to be said about it in the report, inasmuch as we avoided meeting the constitutional question in the decision.
You mean to say that your opinion in Santa Clara settled no constitutional question?
That's exactly what I mean. We ruled in favor of Southern Pacific Railroad, but very narrowly on the question of taxes. Justice Harlan wrote the majority opinion. We found that Santa Clara County had made a trivial mistake in figuring the taxes, and that was that. We made no ruling on corporate personhood, and we all knew that. Court Reporter Davis knew it too, but he chose to add that bit about the 14th Amendment protections for corporations into his headnotes on the case.
Excuse me, Your Honor. What are headnotes?
Headnotes, the court reporter writes up a kind of summary that lawyers find handy if they're too busy, too lazy, to read the official opinion. The summary is called a headnote. It carries no legal weight whatsoever. It is the work of the reporter, not of the court. Everybody ought to know that.
And long after your time, in fact, the court made it official in 1906, when it ruled exactly that. Headnotes were the work of the court reporter and not the court. That came down in United States versus Detroit Timber and Lumber Company, 1906.
Just so.
So, you are saying that John Davis's headnotes were misleading?
Well, they must have been. They seem to have misled plenty of law professors since then.
You say so? Why do you think he wrote them the way he did?
Well, your guess is as good as mine. I had good reason to trust Davis' judgment. Years before, he had been my boss in an important case in an international court in Geneva, where we won a lot of money from the British for their support of the Confederacy in our Civil War.
How much?
About $15 million. That's how I came to national attention. Maybe I should have watched Davis more carefully, but I was so confoundedly busy with cases, and his credentials were impeccable. Son of a governor, brother of a congressman, Harvard College, lawyer, journalist. He once interviewed Karl Marx. He was a diplomat, state legislator, railroad president, and related by marriage to a signer of the Constitution.
A genuine member of the American establishment.
Yes. Though, now that you mention it, I had some complaints about his accuracy.
For example,
Well, let me see. Seems like I remember a commercial publisher of Supreme Court proceedings was worried about its reputation because of the discrepancies between Davis's official records and their records. They stood by their own records.
anything else?
Well, there are several cases missing from official court records. The Senate complained about it. Now, I started looking into that one, but shed this mortal coil before I got very far.
Several. There were 250 cases missing. Okay, but there is still another piece of this big puzzle. Why the huge change in Supreme Court sentiment?
Sir?
Well, in 1880, in a decision, you're telling us officially, that the Constitution did not mean to restrain states in the regulation of corporations. But just 6 years later, you're all telling us, unofficially, that corporations have 14th Amendment First Amendment protections. What really happened? And before you answer, let me tell you that some modern scholars think it was Roscoe Conkling who turned you around.
They are still talking about Roscoe Conkling?
Why not? Lawyer, congressman, senator, two-time Supreme Court nominee, Republican Party leader, corner in the scandalous marital triangle. What's not to talk about? You remember the case he argued in 1882?
Yes. San Mateo County versus Southern Pacific Railroad Company.
Right. The case was a lot like Santa Clara. But remarkably, Conkling was a surviving member of the congressional committee that had drafted the 14th Amendment. Fancy that! A living authority on congressional intent. You remember his histrionics?
Oh, how could I forget? During his argument, he flourished that journal of his. He called it the Journal of the Drafting Committee, and claimed that the committee had wavered back and forth in its wording, draft after draft, between person and citizen, finally choosing person as the word more potentially inclusive of corporations. It's a fine story, but it went for naught because the court made no decision. You see, the case was rendered moot when the railroad went ahead and paid some of the taxes San Mateo County claimed.
Tell us honestly, Your Honor, was it Conkling's version of history that turned your court around?
I'd rather not say.
Do you know that Conkling's story was a complete fraud?
No, but I'm not surprised. Conkling was a bit of a rascal, a rich rascal at that, powerful. There was talk of his turning down the Supreme Court nominations because he could make more money staying in New York.
Well, of course you wouldn't know. The Conkling Journal, so-called, disappeared for a long time, but turned up in the 1930s when a Stanford law librarian examined it and found none of that switching back and forth between person and citizen. All drafts of the amendment had used person. Congress had never meant to protect corporations under the 14th Amendment, not once. Do you know how much Southern Pacific paid Conkling for his performance?
A lot?
$10,000. The average annual wage was about $500, and worth every single penny to Southern Pacific if the impact showed up 4 years later in the Santa Clara head note. Judge Waite?
I resent your implication, sir.
Well, no doubt about it, the railroads knew how to spend their huge Civil War profits to best advantage. They rented the very best lawyers with the very best connections, like Conkling, and they curried favor with the most important judges, such as you.
No comment.
Judge Waite, a man like you acquires many important papers in the course of his career. Many of yours are stored in the Library of Congress. And last summer, my wife and I examined yours, dated 1884 through 1888, the year you died.
Did you indeed?
Sir, we did. One thing we learned was how common it was for railroads to provide favors to you and other judges, even as you adjudicated railroad cases. For example, it was customary for railroads early each year to send you and other judges a free pass for that year. You were especially favored. When you took a long trip, you often had a private Pullman car at your disposal. And of course, you left the travel details to your son, a railroad executive himself.
What of it? These kinds of considerations are very common, even in your own time, I should say. I heard such talk recently in this very room about Justices Thomas and Scalia accepting favors from some Oklahoma tycoons, the Koch brothers. No one likes it, but it's a fact of life.
How true. But when word got around, some citizens took it amiss. They complained about conflict of interest. Be that as it may, Congress put an end to the practice when it passed the Interstate Commerce Act in 1887. It was an era of reform, it was. And end, they thought, to corruption on the bench, supposedly.
Yes, we all got little notes from the railroad asking us to return our 1887 passes.
Yes, we saw one of those notes among your papers. Well, let's go back 1 year to 1886, before your passes were revoked. In January 1886, you received at least 3 annual passes. That same month, the Supreme Court heard arguments in Santa Clara County versus Southern Pacific Railroad Company. The decision came on May 10, 1886. On May 25th, Court Reporter Davis wrote his note to you about 14th Amendment protection for corporations.
Yes, that timing sounds right.
During that same period, you and your daughter prepared for a trip to Alaska. Your son had been arranging free transportation with various railroads and steamship lines. One of the railroads was Southern Pacific. You and your daughter arrived in California in late August. Your host in San Francisco was Mr. Leland Stanford, former governor, U.S. Senator, President of Southern Pacific Railroad. He extended every courtesy. He gave you letters addressed to his railroad employees, telling them to do all they could to make you and your daughter more comfortable in your travels. He even sent muskmelons from his ranch. Stanford arranged an excursion to Monterey for you and several California judges. You wrote a letter home on September 3rd that described the excursion. You referred to a private railroad car and abundant Chinese servants everywhere you went.
Oh, yes.
Another letter on September 15th. More railroad travel in California, this time northeast of Truckee, with luminaries of law, government, and the Mormon Church. Finally, a steamship to Alaska, where an entrepreneur tried to interest your daughter in a lucrative business venture. Now, we figure the cost of first-class travel alone was over twice the average annual wage, at least $1,000. Plus the cost of those private cars, which often came with kitchen, cook, and a servant or two. Plus the excursion to Monterey and Truckee. Now, Judge Waite, allowing that the times were different then, this practice was virtually like giving you justices your own private jet planes fully staffed.
All right, we did travel in comfort, but I never allowed any of that to affect my judicial decisions.
Perhaps not. It's hard to tell. But it didn't look so good. It looked awfully like conflict of interest, at the least, and graft at the worst. And eventually Congress did put an end to such things with the Interstate Commerce Act.
So they did.
Let's talk about a fellow Supreme Court Justice, Stephen Field.
Must we?
I know you loathe each other, but I need to tell you some things you don't know about them.
I think I know enough. Now there was a genuine railroad lackey. We were all favorable to the railroad. Most of us had been railroad lawyers, but Field was a complete lickspittle. He was always after me to let him write every opinion that touched railroad interests, everything. I finally had to take him aside and explain how bad it would look for him to write an opinion that dealt directly with his personal railroad friends. The man had no shame at all when it came to railroads, and everybody knew he was in their pocket.
Judge Waite, you have no idea. He did his worst in 1889, the year after you died. It was another railroad case. Minneapolis and St. Louis Railway Company versus Beckwith. Now in this case, the court actually ruled against the railroad, saying, hey, you railroad guys, you owe Mr. Beckwith some money because your locomotive killed 3 of his hogs, plus punitive damages owed to Iowa, the state of Iowa, this state. Now this case had nothing at all to do with corporate personhood. It had to do with hogs being killed by a locomotive. But Field is writing the majority opinion. He's writing the majority opinion, and guess what he does? He throws in a completely gratuitous citation of Santa Clara as a precedent for corporate personhood. That first citation in a majority opinion made it official. And he did it knowing full well that Santa Clara was no such thing, that personhood was in the head note, not the opinion. How can we say that? Well, for one thing, he was there just as you were there. And for another thing, he complained at the time that the majority opinion in Santa Clara had settled no constitutional issue. His complaint was even published in a Fresno newspaper.
I have to agree with you. I never would have thought a Supreme Court justice would sink that low. Not even Field. Completely reprehensible.
But Field was not alone. Sitting with Field on the same court that disposed of Beckwith's hogs were 6 fellow veterans of the Santa Clara court. Your court. Miller, Bradley, Harlan, Matthews, Gray, Blatchford.
My God. What a dark day for the U.S. Supreme Court.
Judge Waite, it almost seems to me that had you been there, maybe you could have kept him on the straight and narrow.
As God is my witness, I do hope so.
Justice Waite, do you appreciate irony?
Oh, less and less.
Forgive me, but this is just too good to pass up.
Yes.
Do you remember who appointed Field to the Supreme Court?
Of course, it was Abraham Lincoln. Lincoln needed political support out west, and there wasn't much support for the Union. Field was a Californian and a strong Union man. He came highly recommended by Leland Stanford, so Lincoln put him on the bench.
Do you know what Lincoln thought about corporations?
Well, I know he did some important work for railroads long before he became president. Plenty of lawyers did. I've heard that he would rather have preferred to work for the other side, but that the other side never had the gumption or the money to hire him.
I've heard the same thing. One of Lincoln's letters from 1864 put a fine point on it.
As a result of the war, corporations have been enthroned, and an era of corruption in high places will follow. And the money power of the country will endeavor to prolong its reign by working upon the prejudices of the people until all wealth is aggregated in a few hands and the republic is destroyed. Letter to Colonel William F. Elkins, November 21st, 1864.
And it was Lincoln who put Field on the bench. Talk about unintended consequences.
But what were they after? Field and his colleagues that drove them to such an extreme. They were not destitute men and had no pressing debts that I know of. It's hard to fully comprehend that level of corruption.
I think it had to be more than money. Maybe money, ideology, and fear. Now, Field was no intellectual, but he had a friend who was. His name was John Norton Pomeroy. a professor at Hastings Law College in San Francisco, who had helped Field with briefs. Pomeroy said this about the 14th Amendment.
The 14th Amendment may prove to be the only bulwark and safeguard by which to protect the great railroad systems of the country against the spirit of communism, which is everywhere threatening their destruction or confiscation.
Money, ideology, and fear. It may take only one to move mountains, but think what you can do with all three, plus a little luck.
It seems like a lesson for your times as well. Enough greed and ideology and fear to go around, eh?
Indeed. Mr. Chief Justice, do you have any advice for the Roberts Court, for the 5 Supremes who gave us Citizens United in 2010?
I do. Stop citing our Santa Clara ruling as a ruling for corporate personhood or any of its constitutional protections. Read the full decision, not just the headnote. My comment about the 14th Amendment was only an obiter dictum, a remark in passing, which they know very well is not the same as an opinion. One reason we made no constitutional ruling on the 14th Amendment protections for the railroads is that we could not construct a rationale. We were up against 7 or 8 decades of case law that drew a clear distinction between natural persons and artificial creations of the government. Constitutional protections were for the former and not the latter. Government could regulate corporations in any way it pleased because corporations were the creatures of government. They had no natural rights, unlike people who enjoy natural rights guaranteed by the Constitution. I could never imagine a plausible rationale for overturning these decades of well-reasoned case law. Neither should anyone else. You must understand, the Supreme Court is not supposed to issue dictates unaccompanied by sound legal argument. But apparently it did in 1889. It did much worse than that. It pretended that our 1886 court had offered a sound legal rationale for corporate personhood. That's despicable and unforgivable, and I'm glad I wasn't around to witness it. For Roberts Court to claim any precedent for corporate personhood protections is to sign up with Field and that gang of 1889. How can they claim our respect unless they mend their ways? Do they think any branch of government can function as it should without the respect of those governed? Let the members of the judiciary branch say, shame on us. Let them turn their hands to the reversal of this damnable error, and let them do it now. That is my advice to the Roberts Court. And just one more thing for the Roberts Court and every other court. The next time some mogul invites you to the Bohemian Grove, the next time some potentate offers a ride in his private jet for a weekend of duck hunting with his friends at their lodge, think twice. Above all, think, why me?
Chief Justice Waite, I thank you. I came here today to hold you to account for this travesty of justice that has corrupted our courts, usurped the rights of the people, drowned out their voice, and now threatens our republic and its democratic institutions. But now I find I must thank you. Your honorable example restores some hope that the court can be worthy of our founders and one that serves the people. Do too many of us believe that our history has nothing to do with our problems of today? Do too many Americans have the collective cultural memory of a gnat? Do we imbue our leaders with godlike abilities? Are we too ready to believe in the story of democracy we learned as children? We must realize with Jefferson that a democracy cannot endure without an informed and educated electorate. I'll go one step further. We must be informed and educated, yes, but also engaged. Never have we needed so much a participatory democracy. Never. The nation cannot survive without informed citizens acting for the common good. Remember, we may not have the money, but we still have the numbers, hands down. Thanks and respect. The rest of my case.